So this video is going to take us through how you're going to go about applying a control of delegated legislation question. So as per usual, we always start with the question. So we are advising Sarah as to the ways that she can challenge delegated legislation. So she's that's the key word. And we're going to consider law and society, which we'll have a look at in a second. So we're thinking about Sarah and we're thinking about challenging delegated legislation. So keep that in mind when we look at the scenario. So she is a passionate protester against war and she's regularly involved in protests around Parliament Square in London, even staying overnight on occasions in a tent. The government has recently become concerned by the growing number of protesters, and to stop the protesters, the government has sought enabling powers. So we've got an enabling act under the Crime and Order Fictitious Act to ban existing, future, and continuing demonstrations. Sarah wishes to challenge this delegated legislation and is seeking your advice on how she can go about this. Now, the most important thing that I will draw to your attention here is Sarah Jones is a passionate protester, but she is not an MP. She is not a member of the House of Lords. Keep that in mind. So let's have a think about the sorts of things that the exam board is looking for. Whenever you have a question about a specific topic, so delegated legislation and the control thereof, you need to have some initial definitions in your introduction. So I'd like to see your lovely definition of delegated legislation, saying that it's powers passed from Parliament onto another body to make laws on their behalf, and the powers are passed through the Parent Act or the Enabling Act. And just a mention that you have your different types. You've got orders in council made by the Privy Council, usually in emergency, or to pass powers when Parliament aren't sitting. You've got bylaws made by local councils because they have greater, and other public bodies because they have greater local expertise in the case of the council, or sort of specific area knowledge in terms of public corporations. So, for example, Transport for London, the London Underground people know about the London Underground, so that's why they are able to do that. But actually, we are told in our scenario, if we pop back up for a second, that we're looking at a statutory instrument. So we're looking to, the government is looking to ban that. So that's going to be done through a statutory instrument. So we need to tell Sarah briefly why Parliament needs to have control. Well, it's to maintain parliamentary sovereignty, and so that devolved bodies don't get too much power. And you might at this stage want to mention controls by Parliament, but have a think about why controls by Parliament aren't that useful. Well, I made the point at the start that she's not a Lord, she's not an MP, so she can't personally use those. Also, it would appear that this statutory instrument has already been brought in, sought to use enabling powers, so that they're already doing it. So it's not something that she can use, and also controls by Parliament are only useful before the statutory instrument has been created. So our focus has got to be on what she personally can do as an individual, which is controlled by the courts. So you need to mention judicial review, and you must say that this takes place in the Queen's Bench Division of the High Court. You lose out on a lot of marks there. And there are a range of orders which the court can declare this delegated legislation. Worth mentioning at this stage, for those of you looking for the really high marks, which I hope is all of you, that Sarah would have to have, and does have, locus standi, as in standing. It's got to directly affect her, which it does because she is one of the protesters. And one of the orders, one of the things that the court could declare is that the delegated legislation could be intra vires, meaning within the powers, meaning it's okay and it can stand. But if it's ruled not to be okay, not terribly good grammar, but you know what I mean, then these are the sorts of orders that can be included. And as per usual, it's very predictable in this way. We are going to state the order. So we're going to be looking at substantive ultra vires first of all, where explaining substantive ultra vires means that the body has gone beyond the powers that they are given. So when you're explaining substantive ultra vires, you can go back to your previous bit where you explained what the Parent Act is, and you can say that the Parent Act allowed for certain things to happen, but it may be substantive ultra vires if the body has gone beyond the powers allowed, such as in the Fulham Corporation case, where the Parent Act allowed for the creation of a sort of shared washing facility, and what was actually created was a laundrette. And you'll be able to apply that by saying, well, if we look back at the scenario, is there anything to suggest that the minister in charge has done anything more than they were supposed to within the Parent Act? Not really. It appears that it allowed them to ban existing, future and continuing demonstrations, which they have. So Sarah cannot use substantive ultra vires. Procedural ultra vires, we're going to state what procedural ultra vires is. So we're going to state this. We're going to explain in a case like the Aylesbury mushroom case. There are some cases which are so famous that they are just referred to by a shortened name, and this is one of them. And you're going to say of the case, well, it was about training board that was set up. The mushroom farmers weren't consulted, even though the Parent Act said that they should have been, and therefore the delegated legislation was struck off because they didn't follow the procedure. But applying this here, is there anything to suggest that there was a procedure that hasn't been followed? No, probably not. And finally, unreasonableness. This comes from the very famous case of Wednesbury, which says that it has to be something so unreasonable that no reasonable body could have come up with it. And for delegated legislation, the case I like is the case of Strickland and Haysborough Council, where singing sweary football songs was banned in both public and private, effectively making it illegal to swear in private. And no reasonable body would have done that had they thought about it. But again, you have to consider, and this I think is the only place that she may be able to get away with it, is it unreasonable for them to ban all existing, future and continuing demonstrations in and around Parliament Square? They're not banning them everywhere. They're only banning them in quite a small area. Unlikely, in my humble opinion. And therefore you are likely, I think, to reach a conclusion that the government was acting intra vires. Make sure for extra marks that you mention that judicial review enforces the rule of law, and that in doing so the court will have to balance public and private interests. Also have a think about the separation of powers. The judicial review is a checking role, making sure that the executive don't exceed their powers. There's no way judicial review can't review the will of an entire parliament. So make sure you have a look back at the scenario above. Did you manage to identify those issues? If you did, have a go at writing it. If you didn't, have a look again and then have a go.